Once again, welcome to today's webinar. My name is Elizabeth Njoki, and this is the firm of Njogu and Associates Advocates. We are a commercial corporate law firm located in Nairobi. We have been doing a series on data protection as part of our webinars. We started early in the year. We looked at data protection in light of different sectors, schools, SMEs, in the health sector, in the education sector. And for the last couple of months, we have been doing webinars to share updates on recent developments on data protection. Today, we are on part 3 of recent developments and in data protection. And the essence of this webinar is just to update us on what is happening in the data protection terrain. What are the new regulations, the new laws, and if maybe there are no new laws that have come up, to look at what is happening in the within the regulator space in terms of recent decisions that have been made, and what is the implication of those decisions on the data handlers, as well as looking into what other jurisdictions are doing. So today's webinar is going to focus on that. And our speaker today is a lawyer and an advocate in the firm of Njogu and Associates Advocates. Her name is Victoria Wainaina, and she's going to take us through today's session. Ladies and gentlemen, allow me to give the platform to Victoria to take us through today's session. Karibuni.
Good afternoon, everyone. Welcome to today's webinar on part 3 of data protection. And thank you, Njoki, for the introduction. My name is Victoria Wainaina, and since we've already been given a background of what we're doing today, then I'll dive right into the discussion. For those who've been following through part 2, we looked at the principles of data protection. So basically, what we are discussing today, the background of data protection. We have the Data Protection Act of 2019 that was put in place to protect personal data, and it also regulates its collection and its dissemination. Basically, it governs it through its life cycle. And what we have here is the life cycle of data. So data is first created. This is the process by which it is collected from data subjects. It is then accessed, then used for the purpose that it is meant for. Then it is stored, shared, and then eventually the destruction of the data. So, and before we continue, I want to be specific that when addressing data protection, for today's particular context, we are looking at personal data, which is the subject of the Data Protection Act of 2019. And what personal data is, it is information relating to unidentified or identifiable natural persons. So from this definition, it is important to understand that it only involves natural persons. These are individuals. Therefore, it does not offer protection to organizations or any other legal bodies. Yeah, so for today's webinar, we'll be looking at the following: a brief introduction, then we look at recent decisions in data protection, the emerging issues, best practices for compliance, and then we'll have a Q&A session after the conclusion bit. So for the introductory bit, it's basically us just knowing that we are looking at, since the last webinar was on 3rd October, we are looking at what has happened in the space of data protection, both locally and internationally, and advice on the best practices on how to deal with issues, personal data. So for our case law, our first case, we'll be looking at, it's a Kenyan case. Credit Watch Investments Limited versus Mbugu and 2 others. It was decided in 2024, November. So in this matter, the appellant in this, the respondent in this case, had appeared before the Office of the Data Protection Commissioner. The Data Protection Commissioner in Kenya is the one who is responsible for handling disputes involving data protection, and is also the enforcing body of data protection. So in this particular case, the respondents in this matter filed a complaint to the ODPC against CreditWatch Investments Limited, alleging that CreditWatch Investments Limited was using their personal data without their consent. And in this case, it was the typical situation where you get a loan from an organization and then you give the names of guarantors. So in this particular case, there had been loan applicants who gave out the name of the respondents as guarantors. And upon the default of the applicants, the guarantors started calling this, the CreditWatch Investments Limited started calling the respondents, telling them that they need to make sure that the applicants of the loan pay back the loans, or they would face consequences. They didn't specify the consequences, but they said they would face consequences. So the Office of the Data Protection Commissioner conducted its investigations, and it found that the CreditWatch Investments Limited was at fault for not obtaining consent from these guarantors before processing their personal data. And so they were awarded 300,000 Kenya shillings each. There were 3 respondents, so each of them was awarded 300,000 Kenya shillings. So after this determination, the CreditWatch Investments Limited was aggrieved with this decision, and so it appealed to the High Court. And as the High Court, the court stated that information regarding personal data has to be obtained directly from the data subject, because the appellant was arguing we relied on the data on the loan applicants to obtain consent from the guarantors, that they expected that when they were being listed as guarantors, the loan applicants had already obtained the consent. So the court found that it was not the responsibility of the loan applicant to obtain the personal data of the consent of the data subjects. So in that particular case, it was found that the appellant was in breach for failing to obtain consent directly from the persons who are affected with its data. And so it also brought about the issue of data minimization, that data should only be used for the purpose for which it is collected. That is one of the principles of processing of personal data. So it was held that the use also of this data was beyond what it was collected for. Despite being guarantors, they were also being threatened. So that went beyond the scope of what the data was collected. And then, so we look at this case. It's case C582. It was filed in 2021, but delivered in October 2024. So this it's an Austrian case. Basically, this was before the Court of Justice of the European Union. And we are looking at case law from the Court of Justice of the European Union because it enforces the general data protection regulations of the EU. This is the personal data law for the European Union. And when we are forming the Data Protection Act of 2019, we heavily borrowed from the GDPR. In full, it's the General Data Protection Regulations. So whenever I mention GDPR, I am referring to General Data Protection Regulations. So in this case, the police seized a mobile phone from a suspect that when they discovered that the person's mobile phone was being used by a person who was transporting cannabis. So they tried to unlock that phone without the prosecutor's approval. And therefore, when this person found out that the police had tried to access his personal data, he approached a court of law and sought guidance, preventing the police from accessing the information on his phone. So upon filing that matter in the Austrian court went to the European Court, to the Court of Justice of the European Union, so that they would get an opinion of whether it was right for the police to access this person's information contained in the mobile phone. And so the court was of the opinion that the GDPR applies not only in the event of successful access of personal data, it also applies to attempts. So this matter was before it, not because the police had accessed the data in the phone, but because they had attempted to access the data. So the court clarified that it doesn't have to be that they were successful in accessing. They only have to prove that there was an attempt to access, because a mobile phone constitutes a lot of our personal information. It contains messages, photos, internet browsing history, which can be used to draw conclusions about a person. So the court was also of the opinion that it doesn't have to be that it was not an offense because the transportation of cannabis only carried a maximum of 1 year imprisonment. You have to look at what the data is being collected for and the overall goal in creating a safe space and also in enhancing security within the European Union. And so with that, it also gave out conditions when that should be met before accessing someone's personal data. So it says that it must be provided by law. It must be provided by law. There has to be existing legislation that gives you the right to interfere with a person's personal data. So, and also this request must also be reviewed by an independent administrative body. This is to ensure that there's a fair balance between the investigation's need to combat crime and also the protection of an individual's fundamental right to privacy and also an individual's right to personal data protection. And also, before accessing the person's data, they must be informed of the grounds on which such authorization is based. So on to our second case, still in the Court of Justice of the European Union. It is also from the Supreme Court of Austria. So this Maximilian filed a lawsuit against the Meta Platforms Ireland. So Meta Platforms is, in this case, he was suing specifically Facebook, which is governed by Meta Platforms Ireland. So he was alleging that his personal data, including sensitive information about his sexual orientation, was unlawfully processed by Facebook. So what happened in this matter, during, let's say, such a webinar, you invite a speaker and then they disclose information about their sexual orientation. So it was a podcast, and the podcast was then uploaded on Facebook. So Facebook used this information about his sexual orientation and then gathered more information from this person through third-party access, such as cookies, to give this person personalized advertisement. So when he found out about this, he approached the Supreme Court of Austria, alleging that his right to personal data had been infringed. And so upon receiving this complaint, the European Union sought the advisory of the Court of Justice of the European Union. So the CJEU stated that the GDPR's principle of data minimization prevents personal data collected from platforms from being analyzed and used for targeting advertising without time limits or distinction. So it acknowledges that, yes, Mr. Schrems made this information public about themselves, so it was no longer protected because he had already made it public. But though he had made this information about his sexual orientation in public, it did not give Facebook the power to obtain further information about this person and then have specific targeted ads for Mr. Shrem. So the upshot of this is that public disclosure of personal data, it does not allow you to process other data relating to a person's sexual orientation outside the platform. Yeah, this is, for example, using third-party websites, which I have mentioned, such as cookies. So in that case, it was held that it was true that Mr. Shrem's right to personal data had been infringed. And so we move on to a different case. This was from Germany. So in this particular case, a bank discovered that an employee had accessed a data subject's personal data without authorization. So upon this discovery, the bank did not tell the customer that his data had been breached. Instead, the bank did its own disciplinary hearings and they took action against the employee who had accessed the data. And then they reported this breach to the Land Commissioner for Data Protection. So upon it being filed, the customer discovers this and then filed a complaint with the commissioner saying that this bank should be imposed a fine for causing breach in his personal data. So when faced with this matter, the commissioner took this matter to the German court, and the German court took this matter again to the Court of Justice of the European Union to interpret for it this matter. So at the CJEU, the court found that there was indeed breach of personal data. However, this particular bank had taken the steps to rectify that breach because it had taken measures against the employee who had breached the personal data. Therefore, the court said that it didn't have supervisory authority to remedy such a breach by ordering the payment of a fine because the breach had been remedied. In the alternative, it was upon the German court to look into its own law and look whether it would be justified to impose a fine on this particular bank. But on its end, the Court of Justice of the European Union stated that it didn't have the mandate to impose a fine because measures had been taken to rectify. And also in a recent case in Nigeria, so Facebook was fined. Okay, this is Meta company. It was about violation by Meta company. It conducted a 38 months investigations looking into the Meta company for alleged violations of local consumers and their data and also breach of privacy laws. So upon finding that there was breach, the court fined Meta $220 million US. So this is the first case against a big data in Africa, that is. And this goes to show that at least for some countries, they're making progress towards and seriousness towards the protection of personal data. Next, we look at emerging issues in the digital space regarding data protection. So there's the issue of use of mobile phones to track suspects. There was a newspaper article 2 weeks ago that contained an investigation report which revealed that Kenyan security agencies have been using mobile phone data, specifically call records, to track suspects, to track suspects. So this raises privacy concerns, especially in regard to extrajudicial killings. We saw that at a certain time in this country, individuals were picked from their homes by police officers, and some of them never showed up. This was because some telephone companies were providing data of individuals to these authorities to track and arrest suspects. So the investigation report also revealed that there's a technology embedded in Safaricom that allows Safaricom to access effortlessly real-time access to customer data. It doesn't have oversight, and which leads to questions of the integrity of such networks. There's also the issue of unwanted advertising. This is the example where the one time you use your M-Pesa to pay for a service or to purchase a good, and suddenly you have reminders every week about offers, about decrease in price of items, and this is done without your consent, because they just assume because you paid with this service, then they use this information to advertise for you their products. So this is not right when you look at the Data Protection Act, because a mobile phone number is personal data, because it can be used to identify you. As we all know, our mobile phones, our SIM cards, our card numbers, they contain our IDs, and when you find our IDs, you get our KRA pins and most of the things that are personal to us. And there's also the issues of use of personal data for targeted advertising. So this is a situation where you access a platform, let's say Google, you look up something and it asks you accept cookies. You accept cookies. So it like goes into your information. It picks up information about yourself. It looks also at your trends, things you search for online, and then based on this, it advertises things for you. Like it's the same case for the citizen who, upon telling the public about his sexual orientation, Facebook took it upon himself to collect all other data about himself and do targeted advertising to this person based on their sexual orientation. And so there's also the risk of AI, which does automated decision making. There's also the issue of algorithm transparency and also risk assessments. An example of this is in 2019, when in the Netherlands, the government decided that they would use an AI platform to determine whether some children deserved aid from the government. And based on this information that they processed through the AI, it was some of them were fined because apparently some of the information was not correct. And actually, children who actually deserved the help of the government did not get it because the government chose to use AI algorithm. So this also poses a risk because AI can also store your data. Let's say when you search something and it retains the memory of whatever you're doing. Currently with the use of ChatGPT, where you tell it, do for me A, B, C, and D, A, B, C, and D, and it keeps memory of this information such that on another different occasion, let's say 2 months from today, you ask something and it answers it based on what you provided 2 months ago. So there's also the risk of AI being used to make decisions about yourself, and also the algorithm, which is based on your previous searches, is also used to profile you as a person. So those are the emerging issues at the moment. And so we look at what's next for Africa. So because at the moment, we have the Malabo Convention. In full, it's the African Union Convention on Cybersecurity and Personal Data. So this has taken quite a long time for Africa to come to terms with, and it has been here for 9 years, since 2014. And it will not enter into force until ratification by 15 member states. And since 2014, this convention came into force on 8th June 2023. That's 9 years after its adoption. So, and 15 countries, the countries that are displayed on your screen are the countries that ratified it. As you can see, Kenya is not one of them. And I don't think it even had the Malabo Convention when it was looking at the Data Protection Act of 2019. It chose to look at the EU's framework and decided to base it on the GDPR. So it needs to be investigated, because for some countries like Kenya and South Africa, which have very good data protection laws, did not ratify this convention. They did make their own data protection laws, but they did not rely on this Malabo Convention. So the Malabo Convention was meant to streamline data protection in Africa, and also cybersecurity, because personal data and cybersecurity are intertwined. Because when we talk about personal data, there's the issue of the data controllers. These are basically the people who collect and process this information on behalf of their data controller. So the data processor can be a natural person, or they can be a system. So, and in this case, when talking about systems, we need cybersecurity, because as we all know, we are moving very rapidly into the digital space, where we need to have the data protected. So that's where cybersecurity comes in. So that was the whole vision of the Malabo Convention, to safeguard both personal data and general data. Because as I said, personal data is only about natural persons, but cybersecurity looks into both personal data and data in general, whether it's from companies, whether it's for natural persons, but it's not necessarily personal data. So that was its aim. And so we can also consider the Africa Continental Free Trade Area, which its main purpose was to enhance cross-border transfer of data, just generally trade, of which transfer of data is also part of it. It's been coming up really nice. We are hoping to see progress in the near future, but it's basically about data as a whole, and it's not limited to personal data protection. And so we look at the best practices for compliance. So businesses and all data controllers and data processors, they have the responsibility to safeguard personal data and ensure there's transparency in their handling practices. So compliance should not be only to avoid penalties. Yes, for non-compliance, you will be fined of penalties, but it's also about maintaining customer trust. It's also about enhancing brand reputation, and it's also about maintaining ethical data practices. So best practices for compliance will be to ensure transparency. This is for organizations. You should inform individuals about how their data is being collected, how it is being processed, and how it is being stored. And if they request information about the security of their data, you are also required to give them information of the steps you have taken to protect their personal data. Another practice is data minimization. This means you only collect data necessary for your specific purpose. Let's say if you only need one thing from a person, you do not need to collect all the information and store it, yet you only needed it for this particular reason. Therefore, this requires that you collect data only for the specific purpose, and once you are done, you can also erase the data. And so you need also to obtain consent. It has to be direct, it has to be clear, it has to be informed consent. This means you are telling this data subject that we are collecting your data for this particular reason. Can we keep it? So for example, it's I think the biggest enforcers of data protection is the European Union, because in most of their transactions, for those who are compliant, at the bottom it says, kindly indicate whether you accept for us to store your data beyond this reason that we have collected it for. So like you have to sign a clause, even in their job applications. You make an application and they ask you, in case you're not accepted for this job, are we allowed to keep this data and inform you of any other opportunities in future? Which is good practice, because it clearly such an organization will not find itself in legal issues of compliance, because they have sought consent before keeping your data for other reasons than what it was collected for. So we also look at the importance of data security. So organizations and also individuals who collect data, who process data, they must implement measures that protect the data from unauthorized access, loss, and breach. And when we talk of data security, we don't only mean about the systems or the machines that deal with it. There's also the human aspect of it, because most data processors are humans. That can also be a source of a breach in security of personal data. And then we also look at the issue of accountability. You ensure that you properly document and audit trails of data processing activities. This is important because in such an instance where you are sued by an individual saying that you process their data information without their consent, then how do you defend yourself? In case, if you're a person that does proper documentation of all your processing activities, then somewhere you will have the indication that this person did give you consent to actually process their personal data. And also two things that were added to the Data Protection Act regarding practices for dealing with personal data. There's anonymization. This basically means that you remove all personal identifiers from a person's data, such that such a person is no longer identifiable. Let's say someone is called John Kamau of ID number this, who lives in this place. You go deleting all the personal identifiers. In this case, their name, it says this is the person's name. Basically, anonymization, you can decide this is person X. And then if this is person X, you remove also the identification number, because it is personal data, because it has the identifiability aspect, because an ID number basically carries a lot of information about a person. So you remove all identifiers to this person. And there's also the issue of pseudonymization. This means you process the information in such a manner that it cannot be attributed to a specific data subject without additional information. Also, the example I was giving, that your name is John Kamau of ID number that, living where and where. So basically, pseudonymization says you store this information differently and also such that if I have this specific information about this person, I do not know about the person until I combine it with another piece of information and another piece of information that eventually I might be able to identify the data subject. So that's the whole essence of pseudonymization and anonymization. This is basically removing identifiers from this person, from the person's information to make them less identifiable from it. And in conclusion, data is the new oil. Data in general and personal data is currently in the need of protection based on the recent developments in both technology and socially. So it calls for strengthening of data protection. And currently for us in Kenya, our move was the Data Protection Act of 2019. There are also regulations that have been imposed to ensure enforcement of data protection. So there's need for capacity building so that people know their rights, that people know the limitations that are there for processing personal data. Because people may not be aware that you have the right to be forgotten. This basically means the right to have your information erased from a system if it is not needed there. So basically, if it's a company where you applied for a job and you did not get the job, you have the right to approach these persons and tell them, this is my information, I want it completely erased from your system. The Data Protection Act gives you that right to be forgotten. That's basically what it means, the right to be forgotten. There may be debates on whether you really can be forgotten, but that's the whole essence, because we're required to do capacity building so as to ensure that in the future where we are headed with the recent technological advancements, that people's personal data is protected, and hopefully in the near future we can look towards what the European Union did, because the European Union decided that the right to data protection should be a distinct right from the right to privacy, because there were debates about whether privacy, the right to privacy is all about, personal data protection is about. And it was found that there are issues beyond data protection, there are issues beyond privacy. So limiting personal data to only privacy may deny data subjects of the protection that is required of them. And so based on that, we can finish on today's segment. We can now proceed to our moderator and any questions. And thank you.
Thank you, Victoria, for that insightful presentation. I do agree with the audience here. I'm not seeing any comments or questions chat section, but I would invite people to ask their questions, and maybe as I allow people to write their questions, or whoever would like to voice them out, I can make a comment. Pick your mind on the same. Victoria, you can also weigh in on the issue. So do you think the government is responsible when it comes to data protection, when it's a data handler, as opposed to when it's the regulator? Because you see, the government is both the regulator, also the government becomes a data controller and data processor. So in your opinion, especially in light of recent incidences like the migration from NHIF to SHA, the issues with KRA being very aggressive with getting people's information, all these aggressive moves by KRA and what we are seeing happening in government. So in light of that, do you think the government is a responsible data handler, as it is aggressive when it comes to being the regulator and issuing penalties. So that is one. I will allow you to answer that or weigh in on that as I see whether there are any questions in the chat.
All right. Thank you for that question. From my own point of view, I don't think that the government is a responsible data processor or a responsible data controller. Because yes, there are policies in place because it's a requirement for every data controller to have such policies, the data protection policies in place when handling information about its citizens. Because as we have seen recently, I think the government may be one of the biggest perpetrators of violation of data protection, because based on the happenings a few months ago with the Finance Act protests, the government itself used the personal data that is entrusted to it by individuals beyond the purpose than what it was meant for. Yes, we need to give our personal data to the government to enable it to provide us with services. And based on the Data Protection Act, the government, being both a data processor and a data controller, it's also required to abide by the Act because it is required to collect the information for the specific purpose that it is meant for. So I don't think the government is fully compliant with the data protection, the regulations, and also the Act itself. But it's made progress in its enforcement measures. But then again, what's the whole essence of enforcement if to the biggest perpetrators, the same cannot be enforced? Thank you.
Thank you, Victoria. I do agree with you. So we can say that the government is a big hypocrite when it comes to the issue of data protection. It should hold itself accountable on the same standards there. So I'm seeing a question here from Atieno. She's asking, can you also talk about data breaches by fellow individuals as opposed to companies? Also, apart from fines, are there any alternative sanctions meted against data offenders in breach but unable to pay penalties? I think you understand the question, Victoria.
Yes, breaches can be conducted both by organizations and also individuals. So for individuals, there are mechanisms for which to rectify issues of violation of rights. And currently, the first port of call is the Office of the Data Protection. But before getting to the Office of the Data Protection, you can address this individual and tell them to stop whatever they're doing to infringe your rights. This is your personal data rights. And if the same is not rectified, then you have the right to go to the Office of the Data Commissioner and ask that this matter be investigated and that you be given remedies, if any. So the court mostly it imposes fines, but not in all instances that it imposes fines. So there are instances where the data commissioner will find that the individual or the company was not informed of the breach. Therefore, they can give an order to the person complained against or the company complained against, requiring them to rectify that breach within a specified amount of time. So instead of fines, the commissioner can also give the remedy of requiring the person who is breaching or the person who is violating your personal data rights, requiring them to rectify that or cease the infringement upon your rights. I hope your question is answered.
Thank you, Victoria. Atieno can tell us whether the question has been answered. I will go to the next question. Can we propose any policy or legislation amendments on the data protection law?
I think for one of the things that really need to be changed in our current data protection law, it involves the use of AI, because legislations are always one step behind of innovation. Because currently, the Data Protection Act 2019 did not foresee an instance where AI will be used to make decisions about people, to profile people, to collect data about people. So the Data Protection Act should be amended to include matters regarding AI tools, and also the issue of algorithms and how they affect consumer protection and how they affect personal data. I think that's one of the biggest issues that needs to be addressed in the current Data Protection Act.
Thank you, Victoria. I see no other question, but I would also like to add something on Atieno's question about what remedies are available when it's an individual who's involved. One thing about the Data Protection Act, it defines who a data processor and the data controller is. So you can find that maybe I, as a person, I have infringed on your privacy rights, but according to the definition of the Data Protection Act, I do not meet the definition. I would not be regarded as a data processor or a data controller. So when that happens, and maybe I have been using your mobile number in a wrong way, sending it to other people, sending you threatening messages, you can also seek the remedy directly from the courts, because now you'll be saying that I have infringed on your right to privacy under the Constitution. So an infringement on your privacy rights when it comes to data, when you're dealing with someone who may not qualify to be a data processor or a data controller as defined under the Act, such a breach, you can get remedied by going the constitutional way and suing for infringement of your constitutional right to privacy. And then you can get compensated for the damages that you have suffered because of what that person has done. Yes, that is just to buttress what Victoria had said. Any other question? Okay, so I'll assume that we don't have any further questions. So with that, ladies and gentlemen, I would like to thank you so much for attending today's webinar, and thank you for your participation. I hope it was insightful for you. In case you have any feedback that you'd like for us to hear, we welcome it much. You can send it to us. Have a great time. Thank you.